So we did a video on X violating court orders, request a contempt hearing with form FL 410. We get a lot of questions about contempt on this show here. And this person says, awesome video. Thank you, Andrew. If I have multiple contempts of the same kind, all relating to child visitation, would I state all of them? I think he's saying, do I put them all in the same order to show cause, or do I, if there's 5 of them, does it need to file 5 of these or just 1? That's how I understand the question.
And it's going to depend on the courthouse that you're in. You know, they may require that each one be on a separate FL 410. And if they do that to him, you know, he's going to get a whole bunch of separate hearing dates and, of course, separate filing fees. The way I've done this and the way I've seen it done in a number of family law cases down in San Diego is we do the affidavit for contempt, and then we would attach papers to the back of that. And so if there were multiple causes of contempt, I would follow kind of like they would do, the prosecutors would do in criminal court, and say count 1, count 2, count 3, count 4. And for each one of those counts, you know, for count 1, it would say, you know, there was an order, it was in writing, the person was served with it, here's a copy of the proof of service. The order or portion of the order specifically said, you know, fill in the blank. And then the next line would be the citee violated that order when they specifically did this. And I would do that for each and every count of contempt. And hopefully the judge lets you do it all on one motion and doesn't make you do like 4 separate motions. It just gets real irritating because, you know, the clerk may schedule them on just all over the place. And down in San Diego, you know, they don't have any control on some of that scheduling. You know, it's all done by the computer, and, you know, we're allowed to put 2 on this date, 2 on that date, and it's just a mess. Now, in some other counties, the attorneys are allowed to set the dates of the hearing, so it's not as big of a deal because you could put all 4 counts of contempt all as 4 separate OSCs and at least have the arraignments, you know, the first hearing all on the same day, and then it would be up to the judge to schedule it for a trial or multiple trials or whatever. But at least the first go round for all 4 of them would be on the same date.
Okay, and the clerk should know, right? This question should be answered pretty quickly and easily at the clerk's office.
I don't know. Sometimes. Sometimes they'll give you that information, sometimes they won't. And in DCSS, you know, Department of Child Support Services, they do a lot of contempts down there. And so the clerks know how the commissioners like to have these done. And so it's a lot easier to answer those questions. Sometimes different judges may have different ways of doing it. And so it may be harder for a clerk to answer that question, you know, and they just may say, you know, I just don't know with this judge. They just transferred into this department, you know, so you just got to do your best, and then the judge will tell you whether the judge likes it or not.
Yeah. Well, I think that's the first step is if your family law clerk's office answers the phone, call the clerk's office and see if they know the answer. And if not, I don't know, I guess try it to do all at once. And
I would try and do it all at once.
Yeah.
You know, and label them count 1, count 2, count 3. If you don't label it real clearly so that they know they're being hit with multiple counts of contempt, it becomes real difficult for the judge to figure out how many counts of contempt there are, because they've got all these facts that are just all over the place. They don't necessarily seem that they belong to any one particular order or any one particular violation. And, you know, I had this case once in front of Commissioner Clements where they were going after my client for contempt. And so I filed a motion saying, I don't understand what the causes of action or the counts of contempt are. And then the judge got real mad at me and said, "No, you just tell me whether your client's guilty or not, and we'll figure out what to do with it at the hearing." And I said,
What?
"Well, that's what he said." And then and then he looks at me and goes, "Do you waive the reading of the counts?" And I said, "No, I don't know what they are." And then he starts flipping through the papers and he's like reading it for about 3 minutes. And he finally looks up at me and said, "I don't know either." And so, he kind of should have done that when I filed the motion saying, "I don't understand what's going on here." But, once he did that, he's like, "Okay, let's figure out how to deal with this some other way." But